Well, hello. I feel like I'm always apologizing for my absence, and here I am yet again. I think most of you know I've been struggling to get my health back. I also have a lot going on in my personal life, and that's going to continue for the next several months. I will try to be here as much as I can, and as always, I appreciate your patience with me and all of your kind words when I'm not able to be here. So thank you guys, those of you who haven't given up on me. We have a lot of catching up to do here, and it always seems like anytime I'm not available, a million things happen every day. So a lot of this stuff will probably not be news to you. You've probably heard a lot of it, but we're going to catch up on it together anyway, because a lot of it has begun but hasn't been completed yet. So it's ongoing issues that came up. So we're going to go back to document 753. And this is where Blake once again asked the court to modify their plan and their scheduling order. In its typical fashion, it's whiny. She's complaining about not having time to prepare for and take depositions. Well, Blake, you should have already had your case locked down when you filed this lawsuit, but instead, you've been on this wild goose chase to nowhere, and you can't get any evidence together. You wasted months laundering and reusing your bulk Costco subpoena, which I'm sure got you a big fat nothing, except for making a ridiculous fool of yourself, telling the world you had nothing, and proving that Lyman will allow you to do whatever you want in the name of his court. I will always maintain that he should have stopped this improper subpoena, written under the power of his court, and he has yet to make any ruling on it at all. And here's the thing. You don't have to have every bit of information in front of you before you take a deposition. If something big comes up later, you can depose again. There was really no reason to put all of this off like this and to have to keep requesting more time. But this is the document where they have the gall to complain about receiving 80,000 pages. Now, if you remember where these 80,000 pages came from, Blake dropped an omnibus motion to compel demanding all of these things. She dropped it at a really inconvenient time, and we all speculated that it was done on purpose to overwhelm and get in the way of what Wayfarer was trying to accomplish at the time. Now they've scrambled up all of these demands, and she's complaining about receiving the very thing that she demanded with her ridiculous omnibus motion. Then we move on to the tattletale portion of the document, where they report that the signal communications have not come through. We saw Wayfarer say that they were having trouble with those documents, but naturally, when Blake needs more time, it's understandable, but if Wayfarer does, they're horrible, awful people. She then moves on to the hypocritical, childlike fussing about Wayfarer's requests, and this kind of stuff is the very childish garbage that I have no tolerance for. I hate to see grown adults, especially law firms, when they start this nonsense that just reminds me of kids arguing in the backseat of a car. But just the hypocrisy of this omnibus motion to compel, what a burden it was slapping it on Wayfarer at the time that she did. They didn't complain, but now she's going to complain when they respond to it. And if you think it's hard to sort through, imagine what it was like to prepare all of that. Stop whining, Ezra. Next, we have document 755, written by my darling Ellen, where she kindly requests that Toddler Gottlieb take several seats. She starts off by asking the court for a protective order against having to produce certain documents that the court has ordered them to provide in docket 749. We see that order right here, that it was granted in part and denied in part, and this was centered around Jed Wallace, and we're going to get into what happened. But for now, as we see on the front page, this was about Case and Coslow again, and this had to do with whether or not certain documents were privileged. As we know, Judge Lyman had an in-camera review of these documents, and this was his ruling, where he granted the motion to compel and said these must be turned over. Ellen says no, these documents are actually protected. Now, why does she say this? Haven't we been through this already? Here comes the bomb. And like I said, you've probably already heard this, but she says that these documents are protected by the attorney-client privilege. When it issues its order, the court may not have been aware that the Wallace parties have been represented by counsel for the Wayfarer parties in this matter since December 2024. And because of this, she asked the court to enter a protective order. This order was in response to docket number 586, which was Blake's motion to compel Coslow and Case's documents. Docket 586 is Lyman's buddy Gottlieb steering him to this conclusion, focusing on the point we talked about before, that when privilege exists, if a non-privileged party is included in the conversation, privilege is lost. This was kind of a big deal at the time, with a lot of people saying, well, hey, Jed Wallace was in this conversation. He's a party to this lawsuit, but he was not represented by Friedman, and so his inclusion in this conversation destroyed the privilege. And that's the point that Gottlieb is making over and over again through this document that kind of started it. As expected, Lyman just takes Gottlieb's explanation and puts it in his order. And these are pages 10 to 12 that are referred to here of Judge Lyman's order, and we see point 3 is the mention of Jed Wallace. He quotes case law that says the disclosure to a third party by the party of a communication with his attorney eliminates whatever privilege the communication may have originally possessed. He talks about how that can be done away with by an inclusion of someone who is absolutely necessary, or if they were used to implement a specific legal strategy. But as always, looks for a reason to exclude that, and he does, and decides that because Jed Wallace was included in these communications, that everybody waived any claim based on attorney-client privilege, and that's what he orders. And now back to Ellen's letter. It turns out Gottlieb spoke inappropriately. And I love this for him, because not only is he being embarrassed here for missing very important facts of the case, but he embarrasses the judge too. And we'll see more about that in just a moment. But, as she states here, Mr. Wallace was jointly represented by this law firm. Wallace did not and could not have waived the attorney-client privilege. She shares a bait stamp here that points to discovery that has already been turned over to Blake, specifically an engagement letter that was signed on December 24th, 2024. So at the very onset of this lawsuit, Jed Wallace engaged Lina Friedman. This information was produced to Blake. They attach a copy of the letter that clearly identifies Mr. Wallace and his company Street Relations as clients of this firm. So attorney-client privilege was not in fact broken by him being part of the conversation. Next, Ellen lists out all of the communications that were ruled as non-privileged based on this mistaken ruling, the ones that should be eliminated. How did Judge Lyman like these apples? We'll see later on. Moving along through the docket, 756 was sealed. Now we're on to 757. This is in opposition to Blake modifying the court's plan and scheduling order, stating that Blake has not shown good cause for it, that she knew these documents were on the way, that she demanded these documents, and that they discussed it in a briefing, the very briefing that the depositions were being scheduled from. The dates of the signal messages were set, and there's really no reason Blake should get more time for this. And then we find some really big news in this letter at the end. I'm starting to wonder if Judge Lyman is a Swiftie by the overreaction he has every single time she's mentioned. But I want you to look at Ellen's words here. This is a very matter-of-fact statement. There's no fanfare. There's no big build-up. This is a professional attorney stating facts about the case that she's litigating. If you take Taylor Swift's name out of here and replace it with anyone else's, there is nothing attention-seeking about this statement. Taylor Swift happens to be a witness that Blake, not Wayfarer, drug into this case. Wayfarer isn't name-dropping her here. This is a straight-up fact that has to be worked around. And Lyman's reaction, I have to say, is so unprofessional and over the top every time Taylor's mentioned. He's the one having a big ol' reaction about a celebrity. He's a judge, a federal judge, in a big case. His brother works in Hollywood. Why is he so affected by celebrity? Settle down, Judge Lyman, and read it out as if she's just any other woman involved in a case. That's your job. Stop doing the bidding of celebrities, Judge Lyman. That is not your job. They're people just like us. Treat them the same as you treat us, okay? So we've known for months that Taylor's father contacted Brian Friedman, that he told him that Blake was attempting to extort Taylor Swift, that she was threatening to reveal private messages to the world, and that she had asked Taylor to destroy evidence. None of that has gone away just because Blake and team wanted to. We've known that this was going to come back into this case at some point. And Team Blake and Judge Lyman act like this is all just completely out of the blue. Here's all Ellen says here. The Wayfarer parties requested an agreement solely to take the deposition of Taylor Swift during the week of October 20th to 25th due to Ms. Swift's pre-existing professional obligations. Tell me what's dramatic about that statement. Tell me how she's using the media. Or is she not simply stating a fact, someone that they need to depose because she has important information, as told by Blake, who happens to be a very busy person about to put an album out? Now, Ellen doesn't even go into that to talk about what a celebrity she is and how she's dropping a big old record and she's tied up in making videos and prepping for that record drop. She doesn't say any of that. All she says is that she has pre-existing professional obligations that make her unavailable until these dates. This is a very reasonable, well-written request for someone that's testimony is very much needed in this case. So that's the first sentence that involves Taylor Swift. What's the second one? The Wayfarer parties respectfully request that the court modify the scheduling order for the sole purpose of accommodating third-party witness Taylor Swift, who has agreed to appear for deposition but is unable to do so before October 2025. Again, a very professional statement that just puts the facts out there. This is not a big old media circus. This is necessary information that has to be communicated to the court in this request. What are they supposed to do? How are they supposed to word this? To make Gottlieb and Blake happy? To make Judge Lyman happy? How much more could she have downplayed this situation? And as a side point, he can rule against this deposition, as we know that he does end up doing. That doesn't mean they can't continue to ask her, is there any time at any point before discovery ends that we can squeeze in a short deposition? That could be happening, and we don't know about it. Remember, at this point, we only hear about things that the court has to resolve because they've been troublesome. So this could have been resolved already and we won't know it. Or it could be that she really doesn't have any moments to spare to do this deposition. If that's the case, she can still be called to court. She can still be called to testify in the trial. Will she? Probably. They like to depose people so that they have a written record of what this witness is going to say. Not just so they can prepare their case around what the witness is going to say, but it's also a record that if the witness changes their testimony on the stand, they can pull the deposition out and use it for impeachment purposes. Or maybe it's something they just forgot and they got a little information wrong. They can be handed the transcript or shown a video of it and asked to expand on their answer and why there's a discrepancy. This will not eliminate Taylor Swift as being a possible witness at the trial. So next we have backup from Wallace's law firm. Now this Taylor Swift thing is going to go on. We're going to touch on it a little bit more, but I also want to do a completely separate little short video to go through how she came to be in this case and what she might possibly have to add to this case. But moving along on the docket, we now come to docket 758. This is from Jed Wallace's law firm that handles most of his communication. Glorious Texan firm with all the sass that we love to read. This time they're a bit more matter-of-fact, giving the details of the engagement letter. We do get a little sass here in pink, where it says the Wallace defendant's representation by an attorney-client relationship with Liner Friedman is not news to Lively. Indeed, Lively knew this at least by January 23, 2025, after she initiated a Rule 202 petition in Hays County, Texas, to obtain the pre-suit deposition of Mr. Wallace. In that effort, counsel for Lively represented in an email to Mr. Brian Friedman that she was informed by his office that he represented Jed Wallace. So Blake wasn't simply informed on September 9th when she received the bait-stamped discovery that we saw in that document, but in fact, she knew long before discovery. She actually knew since January 23rd. Let's take a look at what this evidence is. This is a notice of errata regarding complaint. This was filed on April the 7th in a separate case where the Wayfarer parties, including Jed Wallace and Street Relations, filed a lawsuit against the New York Times. And at that time, Doe's won through 100 because they weren't quite sure who all was going to be involved in it. Again, the proper way to file a Doe lawsuit. But we see in the very first paragraph, all of the plaintiffs are listed, ending with Jed Wallace and his company, Street Relations, by and through their counsel. Who's the counsel? Brian Friedman, Miles Cooley, Summer Benson, and Jason Sunshine. Attorneys for plaintiffs, if you're still unclear, we look down and we see who all the plaintiffs are. Jed Wallace and Street Relations are at the very bottom there. This was known way back then. What else? Here's another exhibit from the same document, and this was filed in the Texas courthouse. But look at what it says in the second paragraph. At a pre-trial conference where? In Texas? In California? No, in the Southern District of New York. Guess who presided over this conference? Held on February 3rd, 2025. If you guessed Judge Lyman, you are correct. And what does it say? Counsel for Wayfarer Parties, who is also counsel to Mr. Wallace. This was made very clear at this conference that Judge Lyman himself presided over and that Blake's counsel was present for. What was the date? February 3rd. It is inexcusable that not just Blake's counsel, but Judge Lyman himself are suddenly pretending to be unaware that Jed Wallace was covered by Brian Friedman. Why am I being so hard on Judge Lyman? Doesn't it seem like February 3rd was a long time ago and he's such a busy man? Maybe it slipped his mind? Well, let's go back about 2 months ago. July 16th, 2025, while Judge Lyman sat down and wrote his novel, the 38 pages, dismissing Jed Wallace, where he would have reviewed the entire case and Jed Wallace's involvement. Let's look at this paragraph on page 16, where Judge Lyman himself wrote, on February 3rd, 2025, the court, as in himself, held an initial pre-trial conference and entered a case management plan and scheduling order in this case. He states docket number 58 as the document about the minutes of this conference that he obviously reviewed at the time he was writing this order. In this document, he's describing the whole history of Jed Wallace's involvement in this case. So how did he come to the wrong conclusion that Jed Wallace was not represented and that Jed Wallace's part in these communications broke privilege? Could it be because he was just basing it all of what Michael Gottlieb was telling him to rule, rather than looking at the actual evidence, looking at his own words that he's decided in his own orders, reviewing the hearings that he presided over in his own court? All that goes out the window because Mike Gottlieb says this is a media stunt and this broke privilege? Because Michael Gottlieb was the only one making this claim. Never before had this claim been made outside of Michael Gottlieb. So, against everything that he knows or should have known about this case, everything that he has written about this case, all goes out the window, all based on Michael Gottlieb's document, saying, oh, privilege was broken because Jed Wallace was here. What is this judge basing his rulings on, if not the writings of Team Blake? Because if he was basing it on the facts of the case, this mistake wouldn't have happened. He would have corrected Michael Gottlieb and said, no, look at my past rulings. Look at this hearing we held in my court on February 3rd, where he was represented by Friedman. And surely Lyman would have happily pointed this out if it was to Wayfarer. And now back to 758. Wallace's attorney, Joel Glover, sums it up by saying, communications amongst and between the Wallace defendants, the Wayfarer parties, and Liner Friedman are protected by the attorney-client privilege. The Wallace defendants have not and do not waive that privilege. Miss Lively's quest for discovery from third parties unexpectedly became a vehicle for her to pursue privileged communications from the Wallace defendants. And so they too asked the court to reconsider the order where it concerns Wallace's communications, and they also request this protective order against disclosure of privileged communications. How embarrassing. How embarrassing for Gottlieb. How embarrassing for Judge Lyman. And now we come back to Taylor Swift for a moment. Of course, Michael Broken Record Gottlieb, the parrot in my thumbnail, has to give his typical, it's all for the media, it's a media stunt garbage. It's literally the only ammunition he has ever had in his bag, and it's about as effective as a rubber band. When he first snapped it, it had a little sting, but it was overall useless. Now, after he has continuously and obnoxiously flicked it for the past 9 months, it's stretched out, it's brittle, it has zero snap, and is nothing but a childish annoyance. And here he is with it again. As I said, we saw Ellen's document. There was no circus, there was no fanfare, there was no big leak to the media by the Wayfarer parties. There were 2 very simple statements of fact requesting the court allow them to adjust the schedule to fit in this deposition of a very busy woman. But in his fit to accuse media stunt All he's doing is bringing more attention to it by his overreaction. This is what happens. Wayfair brings statements of fact that they have to bring to the court. They are litigating their case. She is a part of it. The accusations come flying out of Gottlieb and Ezra's mouths. Lyman jumps on it too, makes a big old grand ruling, and all of that hits the media, and that's what creates the frenzy, not the simple professional statements made by Wayfair for a matter they must address before the court. It's ridiculous. I'm so tired of the accusation. It's so worn out. And then they turn around and turn that, and they're the ones who turn that into a big old media stunt. And Lyman helps them. But the other thing that drives me crazy is that he misrepresents the role that Wayfair played in Taylor Swift ending up in this case in the first place. He says the Wayfair defendants have repeatedly sought to bring Miss Swift into this litigation to fuel their relentless media strategy. Is that true? And then he makes a big deal about the wording that she agreed to sit for a deposition. Buddy, you don't have a choice. When you're subpoenaed for a deposition, you don't have a choice. You don't get to agree or disagree. So this little wordplay is useless. He says they haven't established good cause. We're talking about one of the busiest people on this planet, about to release an album that's going to come with, like I said, video making, all kinds of things that we can't even imagine. She just got engaged. She's got a million things going on. And if they had expanded on all of that in their letter, they would have been accused even more of it being a media stunt. They kept it simple because of these tiresome accusations that even Judge Lyman accuses them of. So when they kept it to the facts and stated something that everyone should realize is true, this woman is busy till then, he says, oh, you didn't establish good cause. There's no winning in this court. What more could Ellen say? It's Taylor Swift. She's busy. She's not available till these dates. That's out of their hands, so how is it not good cause? If they had addressed all the times that they tried to set this up, again, they would have been accused even more of media stunts. So they kept it simple, and even doing that, they can't win. They get accused of a lack of diligence and disrespect for Miss Swift's privacy and schedule. And that's astounding. How did that disrespect Taylor Swift's privacy and her schedule? Her own attorneys stated the same dates that she's available to be deposed. What privacy was invaded here and disrespected? What's astounding is this moronic document. And then they go on and talk about Miss Swift for a whole paragraph and dare to mention the barrage of press stories. Wayfair was appropriately dealing with Taylor Swift's subpoena quietly in Washington, D.C., and none of us had any idea it was happening. It would have come and gone without notice. Why do we all know about it in the first place? Because Blake inappropriately filed document after document on the New York docket that the whole world was watching. That's how the world found out that Wayfair had subpoenaed Taylor Swift. By filing motions to quash a subpoena that had nothing to do with them. Do you understand how inappropriate that was? And in the separate video I'm going to do about Taylor, we're going to trace that it was actually Blake in the initial disclosures that brought Taylor into this. When you list someone in your initial disclosures as having facts relevant to the case, what happens? Opposing counsel subpoenas them. They ask for the information. They ask to depose them. Standard legal practice. Guess what you don't have the right to do? To file a motion to quash on behalf of someone else. Do you remember when I filed my motion to quash in this court for my subpoena? I mentioned how inappropriate the subpoena was, how it was invalid, as written. And I listed all the reasons of it. What did Ezra say? That I had no right to speak on anyone else's behalf for their subpoenas to be quashed. Do you guys remember that? But what did she do? What did she attempt to do when Taylor Swift is subpoenaed? She tries to quash it. These people are so hypocritical. That's what's astounding, Michael Gottlieb. They're the ones who made it known to the world by bringing it to the New York docket where it didn't belong, and they all knew it. And then when Brian Friedman responded, as he had every right to do, Judge Lyman, all up in arms, gets on there, bringing that gavel down, removing these documents from his docket. But guess whose documents are still on his docket? Untouched. Blake's. Why didn't he strike it all? Why didn't he strike all of it? And you can say, well, Blake filed for him to strike it. Wayfair didn't file for it to be struck. Don't forget that some of those filings he ruled sua sponte, which means on his own without being requested by anyone. So he didn't just remove the things that Blake asked to be removed. He struck everything Wayfarer did, even though they were replies. So Blake's motions were completely inappropriate. She had no leave. She had no right to file any of those documents, and they still sit there. But once she filed those documents, Wayfarer had a right to respond. Those responses are long gone. How is this happening in this case? But here we are. And like I said, I'm going to go through Taylor Swift specifically in a separate video, because this isn't finished yet. But as a quick review, and these are the things we're going to touch on in that video, Blake is the one who used Taylor's name to get her way during the making of the movie. So Blake is the one who brought her into this story from the get-go. Number 2, Blake named Taylor in her initial disclosures as someone with knowledge of the case. Of course, Wayfarer followed up on that. It would be malpractice if they didn't. Number 3, Blake gets accused by Taylor's father of telling Taylor to destroy messages. That's witness tampering. 4, Blake's accused by Taylor's father of attempting to extort Taylor and threatening to leak her private messages. And if you remember, right after this happened, a leaked video inside Taylor's home gets leaked. It was from years ago, and Blake was present. None of the other people present at this private get-together in her private home had any reason to leak this. Number 5. When Wayfarer subpoenaed Taylor, as is commonly done with people found on initial disclosures, as someone with knowledge of a case, as I just went through, Blake had a fit all over the New York docket trying to stop the subpoena. Number 6. Blake's team spilled the accusations of Wayfarer harassing Taylor all over the internet. A quick Google search will bear that out. You see statements made by Blake's team. Who made the spectacle? Who brought this woman into it? And who keeps making the spectacle by issuing statements to the press? Not Wayfarer. Number 7. Blake has since attempted to stop Wayfarer from being able to get any information from Taylor by filing motion after motion and coming and crying to Judge Lyman. These are the facts. Back to Gottlieb's letter, he says that Wayfarer doesn't even attempt to explain their need for this deposition. Are you serious? They told the court in July the relevance of Taylor Swift. Do they really think that the Wayfarer party was just going to drop that? Here goes his old brittle rubber band. The Wayfarer defendants have consistently sought to use to generate a media spectacle in this matter. No, they're not the ones that keep making statements to the press about Taylor Swift. That's you guys. Nor do the Wayfarer defendants address the potential disruption in the case schedule, including the potential need to take additional discovery and depositions following this deposition. Well, your client brought her into the case, sir. And so they asked the court to deny this. None of this media spectacle has been started by Wayfarer. And now this letter inflames it, and of course, he will pass the baton from here to Leslie Sloan, who will run with it straight to the media to inflame yet another story. We saw it happen. If you missed it, Google it, look it up, see who brought this to the media. Ellen had 2 simple statements of fact in her request that she had no choice but to ask the court. Blake made a spectacle. Then in his little attachment, he has emails dramatically redacted, as always, to make them seem more important than they actually are, because when we see them unredacted, there's nothing significant under these big, bold, black splotches. And we see they're just as nasty in their email communications as we expect them to be. And if you haven't seen it and you want to read it, just pause the video here. I don't even want to read this childish nonsense. But I just want to say it's not true that Taylor Swift was never mentioned. They probably haven't brought her up because every time they do, this accusation comes up, but it doesn't mean that they gave up on deposing her and that they haven't been attempting to set it up all this time. Imagine how difficult it is to get in touch with this woman. All I've got to say is these people are terrified of what Taylor Swift is going to say, but they can't stop it. Then we get this really quick statement from her attorneys that Team Blake read way too much in by saying, oh, she didn't agree. As I said, you don't get to agree or disagree about a deposition. But we see they have been communicating, and they have told Wayfarer that they could accommodate a deposition on the week of October 20th. I don't think it's a stretch for an attorney to receive a letter and say, well, she's available the week of October 20th, I don't think it's a big stretch to come to the conclusion that she's agreeing to be deposed during that time. So it's not a big deal that they use the word agree, because I think anybody who gets dates that a person is going to sit for a deposition, I think anybody would say, oh, okay, she agreed to do it here. She agreed to do it at this time. So a big something over nothing. Them saying, oh, she didn't agree. We're going to stop this update here so it doesn't get too long and so I can hurry up and get this out, hopefully today, and start working on the next update. And hopefully I get caught up before Monday, which will probably have another big mountain of documents.